we do have one of probably the hottest topics that we get in the MLS. And probably one of the most controversial topics, which is assignment of contracts.
Yeah.
And it's something that we do allow in the MLS for people to do. It is a business model for some people. And it is definitely, like I said, one of the most active questions we get. So before we get into the MLS rules and how that works, I do want to introduce Sam Saad, who is an attorney, also owns a title company, and is also a sponsor actually this year of our TechCon. So appreciate that. And Sam's been on before, and has done everything from, I know he's doing an upcoming FERPTA class with us at the association. He's been a great partner with us. We appreciate everything he's done for the association, but spending his time here with us today to talk about the assignment of contracts. So with that, Sam, I'll turn it over to you.
Sure. Thank you very much. Good morning, everybody. My name is Sam Saad, and we're going to talk about assignments of contract today. I'm going to go ahead and share my screen, so give me 30 seconds.
You're good. We can see it.
So let me just get this going the right way. Nice. Okay. All right. So, can see it? Perfect. All right. So, forms and rules for signing contracts. So, first of all, I'm an attorney. I practice law throughout Florida, particularly in Southwest Florida. But because I'm an attorney, we're going to start with a little disclaimer that I'm going to give you guys a bunch of information today, but it is not legal advice per se. And if you want an attorney-client relationship, you have to call me separately. With that being said, I will take questions. A little bit about me so you know who I am and what I do for a living. I am a real estate attorney, and I practice in this area of real estate contract law all day, every day. I serve on the committees at NABOR and FARBAR that draft the contracts. And what we're going to be talking about today is directly related to those contracts. So I'm very familiar, intimate details of those, and you can ask me questions about that. First off, what is an assignment of contract? It is where one party to an existing contract hands off the contract's obligation and benefits to another person. And I wrote this definition a little bit generically. What I really mean is buyers. Sellers cannot assign contracts. Why? Because they are title holders to the property that underlies the contract, and they would have to physically transfer title to somebody else, and the contract doesn't allow for that. Buyers, of course, can assign contracts however they choose, depending on the form of contract and the language that it contains. So just a little brief. FARBAR is, of course, the contract that primarily used in Royal Palm Coast and throughout the state of Florida. Again, I serve on the committee that drafts the FARBAR contract, and it contains a very simple, easy assignment clause. The buyer has three options for the assignability. I should say the parties have three options for the assignability of a contract. That's the right of the buyer to transfer the rights and obligations under the contract to somebody else. And they what you're seeing on your screen is the assignment clause. It's paragraph 7 of the FARBAR, whether you use the standard or the as is, it's the same in both. And it says the buyer either first checkbox may assign, let me just get my laser pointer, may assign and thereby be released from any further liability under this contract, or the buyer may assign but not be released from liability under this contract, or may assign this contract, may not assign this contract. If no box is checked, then buyer may not assign this contract. So let's talk about those three options and what the default means. Okay, So you're going to negotiate assignability in your offer. And I know we talk about wholesaling and flips and things. Assignability is very, very important. So you have these three choices. First of all, if you assign and the buyer is released from liability for performance, then your buyer walks away, hands clean, goes away, and the seller deals with the new buyer, the assignee. So you've got an assignor transfers to an assignee, and then the assignee, if there's a release of liability, the assignor goes away and the assignee steps into the shoes and becomes the buyer. Or choice number two, you can assign the contract and the buyer is not released from liability for performance. And that means that even though the assignor, the buyer, has assigned the contract to an assignee, the new buyer, the old buyer still is liable if the new buyer fails to make a deposit, fails to close, doesn't get the financing and has a problem with the property. All those things fall on both the assignor and the assignee. Or assignment may not be allowed, in which case the seller knows who they're dealing with and they only talk to that person. They don't have to worry about somebody else stepping into the shoes of their buyer. So on the FAR bar, there is no form of assignment provided. So you do need an attorney, because you're not supposed to practice law without a license, to draft an assignment form. And that assignment gives, rights and obligations between the assignor and the assignee. So a lot of people like to do this in a wholesale type transaction where a buyer gets a property under contract and then they want to walk away and be released from liability, and they want the assignee to pick up all the obligations and replace the deposit and pay them an assignment fee. All of those things are covered in the assignment agreement between the assignor and the assignee. And the other thing I want to say about the FAR bar contract is the default is to make it not assignable, which is the opposite of Florida common law. So don't skip this box, these boxes in section 7 of the FAR bar contract, if you're going to want to flip the property or assign the contract to somebody else. If you mistakenly don't check the appropriate box, then you cannot do that. Okay. Next up is the NABOR assignments. So NABOR does provide a form, and I'm going to zoom in on it so that you can see it a little better. And you pretty much fill in the buyer assigner's name, the assignee, that's the party receiving the property, or receiving the contract, I should say, the seller's name, the property address, and the date of the contract for the underlying contract, and then the buyer assignor, and it's accepted by the assignee, and a little bit about the NABOR contract. It is freely assignable if you are more than 15 days from closing. So there's not a choice in the NABOR contract like there is in the FAR bar contract. The seller does not sign a form, and the seller's permission is not required to assign unless you are within 15 days. Then you need a lawyer to draft you an assignment form, or add some language like I wrote here. Seller hereby consents to the assignment contemplated herein, and the seller would sign the assignment. You'll notice, however, though, on the NABOR form, there's no place to put other terms like deposit transfer or assignment fee. So if you're doing this as a business, you're probably going to want to use the FAR bar contract in the first place. And then you're going to need an attorney to draft the assignment language based on the deal between the parties. So thinking about a little bit about some tips and some rules for assigning contracts. You really need, I wrote in here must have, you really must have a written assignment agreement. Um, the contract is between the seller and the buyer, but the assignment agreement is between the current buyer and the new buyer, the assigner and the assignee. And you're going to want to cover some various provisions. Again, you're going to want to talk about replacing the deposit, an assignment fee, uh, if an indemnity clause is typically used, so that if the seller says that the assignor cannot get out of the contract and be waived of liability, like the second box on the FAR bar form, then the assignor may want to be indemnified by the assignee should the assignee screw up or not perform and be in default, and the seller looks to both parties. You end up in a complicated relationship, and you want to make sure that if you have the assignor, that the assignor gets out of it, or if you have the assignee, you may want the assignor to stay in and back you up. So your role in the transaction depends on how you're going to want that assignment agreement drafted, and you must have an attorney draft that. And I put some bullets in here just talking about the FAR bar. You can, if you are allowed to assign, you can actually assign all the way up to the closing date. So it gives you more time. NABOR, you have the 15 days that we talked about. And NABOR, of course, wants to accommodate document preparation. That's why they give you the 15 days. What happens is, if you're in the FAR bar contract, you may have an assignment that doesn't get negotiated and signed until like the day before closing. Well, if the seller's documents have already been prepared by the seller's attorney or title company, then you got to redo those documents. And so the NABOR contract tries to prevent that. A few tips. First of all, sellers typically don't like assignments. They want to know who they're dealing with. So they may push back on a free assignment, especially one where the buyer can get out and be relieved of liability. But there may be very legitimate reasons for a buyer wanting to assign a contract outside of flips. For example, in estate planning, buyer may be putting it into a trust. They may be adding a spouse. They may be doing a ladybird deed and adding children. It may be an investment property, and the buyer may be working on getting their LLC formed. LLCs typically take 20 to 30 days to form in Florida. So they may say, I really want this property, but I want to put it in my LLC. My LLC is not ready yet. And so they will put the contract in their own name and transfer it into an LLC before closing. So in an investment property situation, you may be perfectly fine where the buyer is not relieved of liability, so the seller has some certainty. And in estate planning purpose, you may want to relieve your buyer of liability, because once the estate plan is in place, typically like a trust would be the responsible party, and your buyer is going to want to get out of the way and let the trust attorney handle it. Investor buyers love assignments because they do allow wholesaling. And wholesaling is a special kind of assignment. Let me just pull my wholesaling slide. Assignments are the backbone of the wholesaler's business. You put the home under contract with the intention of the wholesaler flipping the contract to an ultimate buyer for an assignment fee or a higher price to the buyer. So maybe you've got a $200,000 piece of property, and the seller is going to sell it for $150 because they really got to get out of it. You pick it up for $150, but you don't have $150 in cash, and so you want to sell it for $200. You wholesale the property. You put the property under contract. You check the box in the contract that says you can be relieved of liability as the assignee, as the assignor. You sell the property to somebody else for the $200, and then you assign, quote unquote, the contract for the 50,000, and you go about your day and the buyer buys the property. Typically, wholesaling is done in distressed properties. Like I'm saying, the seller's got to sell, and then the wholesaler takes the role of the middleman, and you find a buyer, even though you've got the property under contract. And remember, this is not like wholesaling is not like flipping. It's not like fix and flips, where the wholesaler doesn't really do anything to the property. They just assign the contract. And with that, I am free to take some questions. That's pretty much all I've got on assignments. But what questions do you all have in your business that I can resolve for you here? And you can put them in the chat. I don't know if you can unmute yourselves.
Yeah, they
Kevin's got a
can't. It's
question. Go
webinar.
ahead.
Yeah, it's webinar style. I see that Tevin raised their hand, but if you can use the Q&A box down below, then
Oh, okay. Yeah, let's do the Q&A. Yes.
yeah. I don't have any Q&As in there just yet. We had a few this morning about volume, but if you want to type your Q&As down below, then we'll have Sam answer it for you.
Yeah, just take a second, type your questions in. I admit I am not as familiar with the Zoom format of webinar as I am with mine, where everybody's shouting.
We've got you covered there. So do you
Perfect.
see lately like an increase in what you guys have been doing for assignment of contracts?
Oh yeah, quite a few.
Yeah.
Quite a few assignments. Feliciano, what are the benefits to the seller? A greater pool of buyers, Feliciano. You would, if you had a particular this is typically for distressed properties for assignments. But if you had a property where the seller needed to sell, they're willing to go in at a lower price, and you could get the property under contract with a buyer, that buyer may immediately want to make some money. And again, as long as the seller is okay with the not be released choice under FARBAR, it really doesn't matter to a seller if the contract is assigned, because they get the deposits. They know who they're dealing with. When it says that the buyer may not be released, then the buyer can resell the contract, and it goes pretty smoothly. Other questions you guys have?
I don't see any just yet. If you want, we can kind of.
Oh, here comes Tevin, just put one up.
All right.
I'm curious about the listing assignments. I used to list assignment contracts, but received a lot of scrutiny for them, so I stopped. Now I see a rise in a lot of agents listing them. So Tevin, I will let your friendly MLS people talk more about the MLS rules for assignments, but they do receive a lot of scrutiny, again, because sellers are concerned about whether they're dealing with the ultimate buyer, which they are not. They're concerned about making sure the deposits are made. If there's a finance contingency, they want to know that that's being diligently performed. So you get a number of issues that you can run into in assignments. But as a general rule, the default in Florida is free assignability. The FARBAR contract changes that default. I wouldn't worry about it too much, though, in terms of scrutiny of the listings. But do you guys know what are the MLS rules? I'm not an MLS expert, I gotta admit.
Yeah, we can talk through that a little bit. So, and to that question, you're going to receive scrutiny because you've got people who are really passionate about the fact that they don't like it, but it is a specific way of business that a lot of people do. So we've got ways in the MLS that people, if they don't want to see assignment of contracts or it bothers them, they can filter it out. So if you start getting back into assignment of contracts and anybody calls you and complains about it, or anybody gets on your case, you can inform them, since you've been on the webinar, how they can filter it out so that they don't see assignment of contracts. So I'm going to go ahead and share my screen. And if you have more questions for Sam, feel free to continue to put those in the Q&A, and we'll kind of come back to him as we go through this. So we're going to start with our rules and regulations. You can find our rules and regulations on the rpcra.org site under the MLS tab. You've got several of it broken down here. The entire rules and regs is down here in this link. So the piece in our rules and regs that does speak to assignment of contracts is right here. This is verbiage that you must put in your listing if it is a listing of an assignment of contract. Now, this isn't to say, hey, I've got a listing with the seller and they'll accept assignment of contracts. This is stating that you're listing something that is an assignment of contract. So it states this is an assignment of contract and must close on, it has a blank space for the date, and then at and a blank space for the agency that will be closing it. So to give you guys an idea of what that looks like inside of MLS, when you are doing an input, there are two different places that you'll disclose that it's an assignment of contract. The first part is status type. Most of the time when you do this drop down, we use the resale property section. If you're in construction with a builder, you use a lot of these new construction parts, but we do have a category here for assignment of contract. So if you are listing one, make sure you select it here first. Also, if anybody complains to you that they don't like assignment of contracts or, you know, they don't want to see it in there, this is how you can filter them out. So you would, when you're doing a search, you would say status type, not assignment of contracts, and that's how you can filter them out. Or maybe you have an investor that really is just looking for assignment of contracts. This is how you would search those listings specifically, and that is under the status type. I see we have a question.
Yeah, your recommendation is if you have an assignment is to release the buyer, but seller always stay. Box 2, I was told in one of my contracts I not need to fill, so if there's an assignment, it must be checked, correct? Elizabeth, yes. You should not skip check boxes unless you intend to make it not assignable. And again, that is the default in the FAR bar contract, which is contrary to Florida's common law. But I would, as a general rule, in terms of liability protection for you and your broker, I would not skip any boxes in the contract, because then the question is, did you mean to skip it? We put a default in the contracts in case you accidentally skip it, but you shouldn't, as a matter of course, skip any boxes. And then Claudia is saying the new end buyer will sign a new contract with the first buyer or with the seller. Claudia, the new buyer, the assignee, signs an assignment agreement with the old buyer that says they step into the shoes of the old buyer, and then they work with the seller directly through the title company or closing attorney. So that's how you handle that.
Perfect. So the other place after you've selected that this is an assignment of contract, not new construction or resale, you'll put it in the remarks in here down below, that sentence that came right out of the rules and regulations. You can see we have typed out right here. That's what it would look like after you put in the blank spaces. So it states, this is an assignment of contract, which must close on 4/1/25 at Paradise Coast Title.
But you won't put in our driving instructions.
No, you wouldn't.
I know, see, I was gonna ask, it's not, it goes in confidential remarks, right?
Yeah.
Yes, it
Driving
does.
instructions, yeah.
I just want to make sure you guys are paying attention.
Perfect.
I was so proud of myself. I got it typed in there ahead of time with your name in there, Sam,
I
but
appreciate that too. Thank you for the shout out.
hey, we all make mistakes. So make sure you put that in there under your confidential remarks, and those are the two places where you will disclose that.
Interesting.
So yeah, that's what our rules and regs have around that. That way you can filter to it, you can filter out of it, but then based off of, you know, and Sam and Jason can kind of talk to this. The other rule piece above this, which is the listing agreement must be signed by a legal owner of record. And this is what kind of comes into question a lot, is how you go about listing that actual assignment of contract.
Right, and I think a lot of the calls that come in are, I go out and I see that Joanna's house, you know, needs a roof. I realize that she's behind on payments, because I'm buying a late payment from Wells Fargo Bank list. So I contact her and say, listen, I'll buy your house for cash. And we sign we go in there, I give her an offer for it. It's not for sale right now, right? And then I go and have her sign a listing agreement. I'm going to list it as well, but I'm going to give her cash. And I'm going to try to make the margin gap between what her and I agree, you know, 100,000, and I list it for 140, hoping to make the margin. So we have a lot of those happening where people are trying to flip it without buying it, so to speak, right? They know it's worth 140, even though it needs a roof. They know she's behind, you know, on payments. So we see a lot of that, that type of stuff occurring. So, you know, we have to have a listing agreement with the owner of record, right? When we call for people, I have a listing agreement because I've got the assignment, I got an offer with her, then the listing agreement's not me, because I don't own the property yet, right? Listing is with the owner of record. So that's where we run into problems. And when I go back and go, hey, Joanna, I need you to sign this listing agreement, but it's 140,000. She's like, wait a minute, I'm paying you 100. How you get 140? So that's the problem that happens. And so for us, the flavor behind the rule is that we want transparency with the seller. We want transparency with the buyer's agents and other agents, transparency with the buyer, right? So disclosure. And as long as everything's there, you know, we're good with it. And there are some people that do get that listing agreement and say, listen, I'm going to pay cash regardless. If you have an investor, will pay her 100 grand on it. But I want you to sign this listing agreement and we're going to list in the MLS for 140. If I can get that prior to the agreed upon date with you and I, then, you know, I'll sweep up the 40. If not, my investor will close on you. I'll relist it in the MLS as not an assignment of contract. So we see a lot of that model occurring.
Can I ask a question?
Yeah.
Is this that we're looking at on the screen? This is a Royal Palm Coast, Florida Gulf Coast rule.
Yeah,
Yes.
Florida Gulf Coast.
It's not a standard across the MLSs though.
No, nope.
The
So
reason I asked the question is the NABOR contract, the listing and sales contract actually say that you are the owner of record or you have a right to sell the property.
Correct.
So that's
Right.
interesting. The NABOR contract contemplates in some form a future owner selling the property before, you know, listing the property before they own it.
So with Naples, the way that where they say, or you have a right to sell it, they would
Right.
request paperwork that shows they have a right to sell it. And it's kind of twofold the same. So with us, we see a lot of people who just regularly do assignment of contracts. They will do a sales agreement and attach an addendum onto it that says, I have the right to relist this. And that's considered in form a listing agreement. It doesn't have to be the FAR bar listing agreement. It is a form of some sort. And a lot of brokerages have made their own
Sure.
that attach onto it. So they have it in the additional comments on the sales contract that says, you know, to see addendum, they have the right to relist this. This will be an assignment of contract. And then they state out the details in an attached addendum, and that we accept as well. We need some kind of form or listing agreement statement that shows all parties agree.
Yeah.
So
and
the
it's
owner, you want the owner of record to know what's going on, not so you don't have surreptitious sales by agents that are not disclosing their flippers.
correct. So yeah, so some have got their own addendums that they've got. It's completely transparent to the original seller that currently occupies a home or owns the home on record. As long as that's in place. So yeah, it does not need to be
Okay.
the actual
That makes sense.
listing.
Tammy has a question about when the transaction closes with the assignee, does the seller get paid or is it just the assignor makes their fee? Tammy, when the transaction closes, the assignee gets the property, the assignor gets their assignment fee, and the seller gets the proceeds of the sale from the original contract. So in their example, the 100,000 goes to the seller, the 40,000 goes to the assignor, and the ultimate assignee buyer gets the property. And then Alyssa's asking about the recordings. I'll let you guys answer that.
Yeah, so this will be recorded and it will be put up on the YouTube channel.
Okay.
All right, I think that's all of our questions.
Yep.
I think that covers most everything. I'll give it a few seconds in case you guys have any other questions there. Sam, you have anything else to add? looking at the
I
rules.
would just say that in this crazy market with assignments and wholesaling and nervous buyer, I mean, we're in a buyer's market now. I mean, that's all there is to it. I mean, any way you slice it, the buyers have authority, and if they want to try and flip it, let them. I mean, as long as you're happy with the price you're getting as a seller, then I wouldn't be afraid of assignments, because again, if you check the box that says the assigned or buyer cannot be released, you know who you're dealing with. You've got an address to sue somebody if you've got a properly filled out contract, and you don't have to worry about it.
Yep. Yep, I agree. And we'll see you tomorrow, right, Sam? TechCon?
Oh yeah, I forgot. I am the Wi-Fi sponsor at TechCon. I'm very
Yeah.
excited. I will be at TechCon wandering around on the Wi-Fi. And if you have any questions, you can run up to me. I'll wear a name badge or a t-shirt or something so people know who I am.
Awesome.
Perfect.
Good
Gina
deal.
needs to know the name of the YouTube channel.
It is Florida Gulf Coast MLS.
Oh, we got a question from Tevin. What's here? Assign. Tevin must be asking something about whether she's allowed to use this language or something.
Okay, assignability rights. This agreement is binding on heirs. Trustees represent administration. Buyer may assign but not be released from
Oh, she said
liability.
she knows wholesalers would add this clause to their contract. Yes, Tevin, wholesalers would add a clause like this. It's not necessary, again, because you simply check the box in the FAR contract. But you certainly could add something like that if you needed to. All of that language is already covered by the FAR contract and the NABOR contract, except for maybe the last part about list the property in the MLS for marketing and selling. But again, you're allowed to do that if you've got the requirements that these folks have said that you have for owner of record knowing what's going on.
Perfect. Thank you, Sam.
All right.
All right, guys. Well, if you have any other questions, if it's MLS related, you can contact us here at the association, or you can email mls@rpcra.org. If you've got closing questions, legal questions, Sam's your guy. His title company is there to help you guys out with that process. And hopefully we'll see everybody tomorrow at TechCon.
Talk to you all soon. Thank you.
Thank
Thanks.
you.
Bye-bye.